Hey everyone, Harry here to talk about the DC Circuit treatment of the gag order that Judge Tanya Chutkan imposed on Trump. So, recall that it went sort of back and forth with Judge Chutkan. He appealed it. There was an issue about whether the word targeting is too amorphous and to be constitutional. And then did Trump, basically a whole line that he brought to the DC Circuit, trying to have the court analyze this as a prior restraint on speech and on core political speech, which it's well known is about the highest hurdle that the government has in order to do. The special counsel counterposed a different theory. No, this isn't about a prior restraint on speech. This is a whole different rubric and a whole different reason for authority and rationale and government interest than trying to suppress speech based on content. This is about the exigent goal of protecting witnesses in a trial. And there's potentially, where you come to gag orders, also about making sure the jury pool isn't polluted, etc. All right. So after Chutkan had refused to modify it, it went up to the Court of Appeals. And remember, about 2 weeks ago, they had on a Friday an oral argument where it looked like they had some hesitation. It went on for a couple hours. They were worried about the First Amendment interests of Donald Trump, and not just of Donald Trump, but of the entire country, needing to hear from Donald Trump, a putative nominee for president of one of the two political parties. And playing off and against all of this and hovering in the background with almost equal weight is the possibility of imposing a stay while they decided this, and that they might, going forward, they might take a while. In other words, a potential delay. Okay, so they make pretty quick work of it, especially since it's a 68-page opinion. I had speculated at the time they probably were already starting to write, and I think that's likely. So it's Judge Millett. It was a 3 Democrat panel, and Judge Patty Millett wrote. And basically, while it was initial reports said they narrowed it, and Trump's lawyers said they got rid of 90% of it, this is a very strongly pro-Chutkan opinion, as I see it. So, first and foremost, they really sounded the right themes. They rejected the notion of Trump as a sort of typical First Amendment analysis, since he's a candidate, and rather they were foursquare in the idea that this is about, making sure witnesses aren't intimidated, a whole separate, purpose. And for that, Trump might be a candidate, but he's a criminal defendant, same as any criminal defendant. That is what the rule of law means, as they say. So really sort of forceful in their articulation of the theme. And that's the theme that Chutkan herself has sounded in her proceedings. It's the opposite. Eileen Cannon has talked about the importance of his being a candidate, and Scott McAfee in Fulton County has sort of waffled. Chutkan's always been, look, I'm not thinking about the election, his candidacy, I'm just going ahead with the trial. So to that extent, they were really, behind Chutkan. Second, this supposed narrowing, pretty small stuff. So first they said, open season on Jack Smith. He's got a thick skin. He can take it, and we're not going to the gag order shouldn't be construed as keeping you from really, all kinds of vitriol directed at him, which is in essence directed at the whole idea of the prosecution. And truth be told, Trump's been doing this for months. This does come with the territory. You know, I was U.S. attorney, and in any controversial case, you had to be prepared to really get criticized, even pilloried in the public eye. That's what the job entails, and so that really wasn't a big deal. And the second thing they said, also pretty minor. They said, "Hey, you can't target witnesses." That's true, but we're making a distinction between criticizing or dirtying up a witness, someone who happens to be a witness, versus criticizing their actual testimony. So they gave an example of Mike Pence, no longer a candidate, but if he had been, and Trump on the debate stage wanted to say that Pence is exaggerating or his claims against him are bogus, etc., that's perfectly kosher. What he couldn't do is say Pence's testimony is false or made up, or do something that actually goes after Pence in his role as a witness. Both of those things are really pretty minor, I thought. And a couple other points that the court made that I think were very important, also kind of along the tangents. So first, they made it clear this is just about targeting, because that's what Chutkan's order was imposed to regulate. But if Trump down the line starts really going after jurors, really going after the evidence, really going after and doing things that there are other government interests in, so it's not just targeting witnesses, but the integrity of the proceedings, Chutkan can amend it. So, they made clear she has additional ability here, and they were just affirming what she had said. And then, maybe most importantly, they took up the timing issue in an interesting way. First, they decided the whole case quickly, 68 pages in a couple weeks. That shows consciousness of the overall schedule. Second, they actually put in there, and they didn't have to, that this trial would be long since completed by the time of the election. And I really think that's dropping a kind of hint saying, if that goal or fact is being really derailed, come on back and we'll see, what we can do. They were aware of the scheduling. And then finally, they could have remanded. I mean, they basically agreed with her on the overall interest, but they did say, it doesn't affect Jack Smith and the 2 points I made. And it would have been, if in a leisurely opinion with all the time in the world, they'd have remanded it back to Chutkan to apply. And that would have occasioned another appeal, even though it would have been completely obvious, from Trump. And here you have, 3 weeks, boom. I think it's clear that they wanted to avoid that outcome. And so they simply applied it themselves. They simply said, as I've mentioned, go after Smith all you want. Trump can't talk about the witnesses, qua witnesses, etc. So all of that I thought was pretty reassuring or encouraging for Chutkan, and for the tea leaf reading of whether they'll be focused on moving the case along. Now back to Donald Trump. He made a move over the weekend at a Republican party dinner that shows real consciousness of this. It was nasty at Bill Barr, whom he called a coward. But I think it was actually pretty on point and on the line that the Court of Appeals had drawn, because, there's nothing about calling Bill Barr a coward that undermines his testimony in any kind of deep way. So I think it showed that he's Trump, so he'll do anything he can to insult and be vituperative and take revenge, all that stuff. And yet he was following pretty much the line that the Court of Appeals had laid down. Okay, so that is the story now with the gag order. Trump, of course, could try to get the entire Court of Appeals to weigh in or overturn it. It's a notably liberal panel on the Court of Appeals. And after that, he could try to get the Supreme Court interested. In fact, the court hasn't previously decided the constitutionality of a gag order against someone who's running for office. And I should add, by the way, the Court of Appeals, this is one of the other reasons they could have remanded. They were focused on the First Amendment interest and letting Trump go right up to the line. They wanted it to be interpreted in a way that once the interest in having witnesses not intimidated had been met, he wouldn't be further muzzled. So anyway, he has a couple moves: try to get the entire D.C. Circuit to hear it, try to get the Supreme Court to hear it. But everything just goes along now, and the gag order remains in place unless somebody stays it. And that would have to be the full D.C. Circuit. I don't see it, and the full Supreme Court. Now, as I mentioned, it's a issue of first impression. You can imagine the Alitos and Thomases of the world saying, "Let's take this case and let's stay the order in the meantime." But I don't think the court is going to has a big appetite for getting involved, and they may feel they need to get involved in the immunity issue and maybe even the 14th Amendment issue. So this gag order issue, even though it implicates, some legal questions that haven't been decided, and of course they could, you start out with a few votes for Trump. And if they were to order a stay, basically that'd be the end of the gag order, I think, while they were deciding it. And so the trial would just go forward. However, they wouldn't put the stay on the trial. So that could happen. Wouldn't be great, but wouldn't be anything like the concern everyone now has. And we'll talk about it in a different YouTube about their staying the whole case or parts of it based on immunity. For the gag order itself, all they could say is the gag order is off, and then he would, go to town as he always does on the witnesses. But for now, with these pretty small exceptions, the D.C. Circuit has strongly backed Judge Chutkan, which matters on the issue, but also more generally. I think we have a courthouse, and the Court of Appeals and the District Court are in the physically same courthouse, where there's focus on, one another and really wanting to be sure that they're all sort of rowing together to the extent they can be. Okay, so I think the gag order issue might now be basically decided unless he pushes on it and she has to exact penalties or change things, et cetera. But I don't see the full DC Circuit or the Supreme Court changing it. So there you have it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.